Thank you, everyone. My name is Poonam Melwani, and I have been practicing at Quadrant Chambers for more than 33 years, doing shipping law, insurance law, and general commercial law. And today I'm here to talk to you about what is apparent bias. Actually, the definition is easy enough, and there have been many House of Lords and Supreme Court cases that tell you what it is. There is apparent bias if the fair-minded and informed observer, having considered all the facts, would conclude that there is a real possibility that the tribunal was biased. And actually the end of that quote tells you why we are talking about this. The issue is whether a decision maker, a person or a body, has shown apparent bias in reaching that decision so that it's not safe and it has to be quashed. And of course, that can come up in a myriad of different contexts. It can come up across the road in the High Court and the Commercial Court, in front of arbitration tribunals, domestic, international, employment tribunals, disciplinary tribunals, pay review tribunals, lots of different areas. Right, let's go back to the test. Whether a fair-minded observer would conclude that there was a real possibility of bias. And what you're looking at here is, what does it appear to be? We're not talking about actual bias. Actual bias has been described as rare and very difficult to prove. And I actually Googled yesterday actual bias and keywords, and I didn't find a single case where it had been found. It was a quick search, there might be one, but they're very rare. Much more common is for the courts to be asked to look at all the circumstances of a case to see if there is an appearance of bias. But let's be very clear, it's still a very serious allegation. You are saying that the tribunal has failed in how it's conducted itself, so it's only to be made on a proper basis. But okay, someone's alleged apparent bias. Then, to see whether it's made out, it's a two-stage process. First, you've got to ascertain all the circumstances which will have a bearing on the question of whether the decision maker was biased. Second, ask whether those circumstances would lead a fair-minded observer to conclude that there was a real possibility of bias. First thing, the test is objective. You're not asking what the litigant, the claimant, feels. Litigation is an emotional, upsetting thing to get involved in, and the one thing the litigant is not going to be is objective. That, though, is the hallmark of the fair-minded observer. This fair-minded observer has a lot of other very important qualities. He, she is not unduly sensitive or suspicious. And the fair-minded observer knows that judges, tribunals, like everyone, make mistakes and have their weaknesses. And the informed observer has knowledge. He can put himself, herself, in the context where the tribunal was, socially, geographically, politically, whatever it is, so that they know everything to be able to see whether you have this very serious allegation of a real prospect of bias. But what is bias? Bias is an attitude of mind which prevents the decision maker from making an objective determination of the issues. And it comes in really very many different forms. But today let me talk to you about, say, two categories. First, cases where the judge or the tribunal has a connection with one of the parties or some other extraneous influence, like a financial interest in the outcome. Secondly, we'll talk about cases where there is a concern that the judge may have closed their mind, in whole or in part, before the time has come when they should be making the decision. Now, category one, where there's a connection or an interest in the outcome, that is something that has come up more and more to the forefront of attention in recent times and is a particular issue for a chamber such as ours. So many members of chambers occasionally sit as an arbitrator. While they're still acting as counsel, occasionally they sit as an arbitrator. And it is often the case that the counsel arguing the case in front of them will be fellow members of chambers and colleagues and, gosh, maybe even friends. And some people would think, oh, how does that work? How's he possibly going to be or she be fair and unbiased if it's a friend? But the well-informed observer would understand that we barristers are trained to be able to put things like friendships out of our mind and to deal with the facts without regard to those. But say a bit more tricky, you could be the arbitrator, and the solicitor on one of the sides could be someone who instructs you a lot and who owes you a lot of money or has a lot of cases coming up. And that would be a concern, right? Because there's an incentive for the case to go a certain way. So good practice, and actually most arbitral tribunals now, the rules require arbitrators to disclose matters like that so that the party with less of a connection with the arbitrator can decide whether they want to object. So that was category 1. Category 2 that I was going to talk to you about is where there is a concern that the judge may have closed their mind before the time has come to have reached a decision. Again, huge range of situations, but let me tell you about a case that went to the Supreme Court. There, the law lords were driven to describe the judge at first instance as having, are you ready, I'm quoting, as having shown a barrage of hostility with immoderate, ill-tempered, and at times offensive language. Again, I'm pleased to say that is not very common at all. In another case, the tipping point that led the EAT, that is the Employment Appeal Tribunal, that led them to conclude that the tribunal below, the chairman, had shown apparent bias, was because the chairman would not accept from counsel for the claimants the authorities that he wanted the chairman to look at in his closing argument. So you can imagine, sir, can I just hand up these authorities? No, Miss Melwani, thank you, not interested. No, sir, please. No, thank you, Miss Melwani, not interested. Unsurprisingly, the tribunal, the EAT, concluded that there was a risk of apparent bias and they quashed the decision. Having talked about prejudging, let's be very clear that to have a predisposition, to have a provisional view, that's not apparent bias. There are many times that all of us barristers will have gone to court and a judge will have said, Mr. Melwani, can I just say, my provisional view is that the point you make in paragraph 27.3 is really not very good, and I'm going to need a lot of persuading. Or they'll say, Mr. Melwani, really, come on. Really? You're really making that submission? And this is fine, and indeed some would argue good, because what the judges are doing are telling you where they are so that you can focus on trying to change their mind or maybe even dropping the point because it's a waste of court time. So that's not objectionable. What is objectionable is a closed mind, a prejudgment. Easy, right, to work out the difference between one and the other? So, let me just remind you as I finish up what the test for apparent bias is. You need to know all the relevant circumstances. You need to be that very special, fair, well-informed and fair-minded observer. And with those attributes, you have to consider whether there is a real possibility that the tribunal was biased. Thank you.